Welcome to this webinar on strengthening law enforcement integrity. My name is Peter Ritchie. I'm a Regional Anti-Corruption Advisor with the ABA Rule of Law Initiative. Firstly, I'd like to thank the 740 people who've registered for this webinar. I'd also like to thank our UNODC colleagues who co-hosted this event with us as part of their usual webinar series. And I'd also like to thank our really great panel of distinguished speakers this afternoon. First of all, we have Ms. Nichanee Wongba from ABA Rowley, who will give us a background on the ASEAN typology of corruption and the risk assessment process. From that, we'll also have Dr. Louise Porter and Dr. Kelly Hine, who'll give us a great presentation on the latest evidence-based research around police integrity. Then we'll hear from Ms. Lee Ambler from the Australian Commission for Law Enforcement Integrity, Mr. Jae Jeong from the Korean National Police Agency. And then we will have a couple of excellent Thai speakers, Mr. Sukapa from the Thai Office of the National Anti-Corruption Commission, and Police Lieutenant Colonel Dr. Tong Putakul from Rangsit University. We will then have Deputy Ombudsman Manuel Soriano and Assistant Ombudsman Lilini Cabras from the Office of the Ombudsman in the Philippines. And finally, we will have Mr. Francesco Keki, who's the Regional Anti-Corruption Advisor for UNODC based in Bangkok. We have a strong technical team behind the scenes and a team of translators bringing this event to you. You'll see the option for translation if you wish. On the bottom right hand of your screen, you'll see a little globe shaped figure. If you click on that figure, you'll see options for to hear this webinar in Thai or Vietnamese or Bahasa Indonesia. Please choose your preferred language. If you have questions for the speakers or even technical problems, you can use the chat box to raise those points or questions. I should also add that this webinar will be recorded, and UNODC has kindly offered to make it available online after the webinar. Before we commence our first session, I'd just like to give just a few words of background to this event. And the starting point really is the relevance and importance of police integrity around the world. And we see from the Transparency International Global Corruption Barometer that citizen surveys of government agencies consistently show that police departments rate amongst the highest concerns of citizens in terms of susceptibility to corruption. And yet, on the other hand, until a couple of years ago, there was actually very little regional or international cooperation around this topic, despite its importance. And we have a sort of situation where many countries, as we'll see from the next session from Nichanee, many countries, at least in Southeast Asia, have very similar patterns of integrity problems with police services. And so we have the situation where a lot of countries are sort of tackling these problems alone, yet they have so much to share with each other. So the primary purpose of this webinar and a series of work that hopefully follows from this webinar that Francesco will mention towards the end. The primary purpose is to promote international cooperation to improve and strengthen integrity, and partly recognizing the mutual interest countries have here, that police corruption is a key enabler of many forms of transnational crime. So there are pretty strong incentives to cooperate with each other in this regard. So thank you again for joining us today. And it's a pleasure now to hand over to Nichanee Wongba for the first presentation. Thank you.
Sorry, I'm on mute. Okay, thank you very much, Kun Peter, for your introduction. And good afternoon, everybody. Also, good morning and good evening as well, depending on where you're joining from. So first of all, thank you you all for participating in this webinar. And I'm honored as an organizer and having the opportunity to present as the first speaker. So please allow me to share my presentation. Hold on for a second. Okay, I hope you can see my screen now. All right, okay. So my name's Nichanee, but you can call me PAR for short. I work for the American Bar Association Rule of Law Initiative as the Mekong Regional Legal Advisor, and I work under the Regional Anti-Corruption Advisor Program, and I'm based in Bangkok. So the topic of my presentation today will be about, okay, my slide is a little bit delayed. So the topic of my presentation today is to describe the most common and harmful forms of police corruption in Southeast Asia. But before we jump there, I will tell you how we got this information. So please allow me to turn off my camera to ensure that my connection is stable for sharing the screen while speaking, because it's gonna rain here in Bangkok, so I don't trust my stability of my signal. And if I got disconnected, I promise that I'll be back in less than 1 minute. Okay. So the background of these, sorry, my slide is a little bit delayed. Okay. So in 2019, ABA really collaborated with UNODC to organize a 3-day regional workshop on promoting police integrity in Southeast Asia. And this workshop was held in Bangkok and gathered representatives from 14 countries, which are 10 ASEAN countries, as well as Australia, Hong Kong, India, and the United States of America. There were 60 participants attending the workshop, excluding UNODC and ABA Raleigh staff, among which 23 women participants. Now, you might be questions why I mentioned about the number of participants. The thing is, if you consider where the participants came from, it can be seen that almost 50% of the total attendees came from the police department. Apart from that, more than a quarter of participants came from the anti-corruption agencies and police integrity oversight institutions. And we also had the judiciary and prosecution joining the workshop. So in summary, I can say that over 80% of the whole attendees were from law enforcement related agencies. And the objectives of the regional workshop at that time, as well as the intended outcomes, are first, to encourage a commitment for reform in the ASEAN region by improving the understanding of the key elements of law enforcement integrity systems, for example, knowledge, policies, procedures, and systems. Second, to further refine diagnostic tools, e.g. integrity checklist, with enhanced indicators covering the nexus between police corruption and exclusion or disadvantaged groups, women, and trafficked persons. Third, to identify the most common and harmful forms of law enforcement corruption in the ASEAN region, and to produce a typology of law enforcement corruption, which I will elaborate on later. And lastly, to serve as a platform to discuss multilateral support for individual countries who express their interest in receiving technical assistance to review their integrity systems. So what we produced from the regional workshop under the third objective, which was to identify the most common and harmful forms of law enforcement corruption in the ASEAN region, and to produce a typology of law enforcement corruption, is what I'm gonna elaborate on today. And the method used for conducting the regional workshop was starting from introducing the UNODC's framework for oversight, integrity, and accountability of police forces, as well as integrity assessment checklist on the first day. Then during the second day, where we designed to identify the most common and harmful forms of law enforcement corruption and produce a typology of law enforcement corruption. The participants were divided into working groups to identify their perception. And on the last day, the participants discussed the finding in the plenary. When the participants were divided into 7 groups on the second day, they were asked to discuss and identify their perception of the most prevalent and the most harmful types of corruption in law enforcement using this typology of law enforcement corruption. There were 13 categories of corruption forms in the questionnaire that we asked the participants to discuss and rank the most common and harmful forms of law enforcement corruption from their perspectives after the discussion. You may see the word draft here on my presentation, but actually the questionnaire was developed before the workshop and was used as the discussion guide. However, after the discussion, we also received proposals from the participants to add 1 more category to the typology. So I'll show you later on what has been added. From those 13 categories of corruption forms in the questionnaire, the participants agree that the most common risk of law enforcement corruption come in the form of gifts and benefits, followed by traffic enforcement and internal payoffs. I will only highlight the top 3 ranks, the top 3 risks, as my presentation will be shared with all of you later after finishing the webinar, so you could keep it. And you may wonder, after doing the quick calculation, that the sum of the responses is over 60, while I shared with you earlier that there were only 60 participants previously. That's because all participants can reflect what their thoughts without being limited to give only 1 answer. So the statistics you are seeing here were ranked by the participants' perspective of the most common risk. Now, similar to the common risk of law enforcement corruption, these statistics show that the most harmful forms of law enforcement corruption were involved with facilitation of illegal trade, followed by external influence and organized police crime. Besides the rank of the most common forms and the most harmful risk of law enforcement corruption that you've just seen, I also gather recommendations from the participants on other police corruption risk typology, which are nepotism investigation, prosecution, systematic issues, underpayment of police, etc. I will need to skip this presentation because you can see it after receiving the presentation, and I only got like 5 minutes left. So here are other recommended police corruption risk typology that has been shared by the participants from the regional workshop last time. So now, finally, the workshop produced the final typology of law enforcement corruption, which consists of 14 categories by adding the procurement as another category and adding misuse of property into a theft. Other recommended police corruption risk typologies that you have just seen quickly, last 2 slides from last 2 slides, were also included in these 14 categories as well, but as samples of an offense on various basis. For example, under external influence, the sample of scenarios of or the offenses could be an influence by powerful people or nepotism to obstruct or pursue an investigation or prosecution. And under facilitation of illegal trade, It could be police bribe regularly to protect the illegal activities. For example, illegal waste dumping, illegal gambling, drug trade, human trafficking, or even prostitution. Under organized police crime, it could be a network of the police directly involved in trading illicit drugs or other contraband. And internal payoffs could be bribery to gain employment, promotion, or transfer to position with opportunity for bribery. By the end of the workshop, the participants produced the recommendations and ways forward to promote police integrity in the Southeast Asia region. So this webinar is also one of the webinar series that UNODC holds to promote and strengthen integrity among law enforcement agencies, as well as the anti-corruption agencies around the region. And at the end of that regional workshop, the participants recommend that we should promote further multilateral cooperation between Southeast Asian countries and entities with an interest in law enforcement integrity, including a strategic plan, and share and promote strategies to mitigate the most harmful and common forms of police corruption. For example, specific measures to improve integrity in common police interactions with the community, such as road traffic law enforcement, measures to prevent improper external influence, or prevention and detection of police linked to organized crime. Besides, we should draw lessons from community-oriented policing, or COP, problem-oriented policing, or POP, and intelligence-led policing, or ILP, as they apply to strengthen police integrity. Moreover, the recommendation from the participant are we should further develop user-friendly tools and techniques to assess integrity risk and to identify integrity strengthening measures. In particular, we should produce a second edition of law enforcement integrity checklist to include links between corruption and gender discrimination and sectoral corruption risk, such as traffic person. And lastly, we should promote and support the use of the integrity checklist in law enforcement strategies. So that's the wrap up of the typology of police corruption forms that I would like to elaborate on today. And if you have any question, you can email me for more information, or if you have any question, and you will hear more insights about other speakers on the rest of the webinar, including the tools to assess integrity risk as per the participants requested of the regional workshop, as per the recommendation that we discussed earlier. So thank you very much for your attention. And if you have any question, please feel free to email me. Thank you.
Thanks very much, Khun Pa. So now we turn to our next session from our academic colleagues, Dr. Louise and Dr. Kelly. Thank you.
Good afternoon, everyone. I'll just start sharing my slides. Can everybody see my slides okay?
Yes.
Yes.
Very good. Okay. Thank you very much for the opportunity to take part today. I'm here to give you a bit of an overview of what we call advanced integrity strategies. So strategies about combating misconduct and corruption. And the work that I'm going to talk to you about today is based on some work that I've been putting together with a colleague of mine, Professor Tim Prenzler at the University of the Sunshine Coast. And I've put the reference at the end, which is the book chapter that we're currently writing all of this in, and which will hopefully be available at the end of the year. And these slides will be available after my presentation as well. So what I'm going to go through today is, first of all, what do we actually mean by advanced strategies? And then I'm actually just going to go through relatively quickly a list of strategies, each one, and the evidence for their success, and then draw some conclusions from that. So what do I mean when I'd say advanced strategies? So these are really strategies that are inventive, sometimes controversial techniques, but they're really about being proactive. So seeking to predict and preempt corruption and misconduct. And so it's about prevention, and that can be primary prevention, so trying to stop things before they occur, but also secondary prevention, so trying to prevent continuation or escalation, so getting more serious. So the first strategy that I'll talk about is really an approach of using a range of sort of diagnostic indicators to actually understand in the first place the problems that agencies might be experiencing. So there's a whole range of indicators that agencies can utilize to try to understand the problems that they might be facing and assess the impact of anything they put in place. These can be looking at complaints, so types of complaints and numbers of complaints by people about police officers, possibly litigation cases. There are surveys that can be conducted of police employees, surveys about whether or not police see things as serious and harmful, much as you just saw in the previous presentation. And also surveys of non-police officers as well. So people that have a lot of contact with the police, and asked about their opinions and experiences. And this could be arrestees, or it could be other professions that work with police, such as lawyers. And then there's a whole range of indicators of police behaviour. So things like use of force, involvement in incidents that lead to accidents and injuries and fatalities, that sort of thing. So there's a whole range of indicators that agencies could make use of to establish baselines of problems and understand the issues, and then measure the impact of any strategies that are put in place. So that's the first strategy. The second strategy is more of a system, early intervention systems. These are often computer-based systems, and their aim is to prevent repeated or escalating issues. And so the premise of these systems is that often it's actually a small number of officers who cause most of an agency's problems, and that people are more likely to repeat their behaviour if there are no negative consequences for that behaviour. So in practice, early intervention systems are about identifying potential problem officers and doing that in a systematic way based on a range of indicators. So again, similar to my previous slide, these can be indicators such as complaints received about officers, the use of force, even things like sick leave and that kind of thing, that agencies can decide on what indicators are appropriate for them and what kind of thresholds officers need to reach to be flagged as a potential problem that an intervention may need to be put in place to address. And usually these systems have an underlying remedial approach to them. So it's not really about weeding out problem officers and sort of terminating their careers necessarily, but trying to understand issues before they get too serious, and trying to deal with those issues through things like counselling and training to stop people from getting into patterns of poor behaviour. And there's a fair bit of evidence that early intervention systems can produce positive effects, certainly in terms of numbers of complaints. Here's an example from Minneapolis and New Orleans in the US, where complaints have dropped quite considerably. And similarly in Australia, again, the use of an early intervention system reduced police complaints. And there's a whole range of studies that you can look up if you're interested. This slide has some references on it. A lot of them are in the United States, but there's also some in Australia and New Zealand as well, showing that these sorts of systems can have positive impacts. So the next strategy that I'll talk about is drug and alcohol testing. So drug and alcohol testing can be targeted in terms of if you have a suspicion that an officer is using drugs or alcohol whilst on duty, or after a critical incident that they've been involved in. It can also be random. So the idea that somebody could be tested, anybody could be tested at any time. And the aim of these is obviously to prevent any harms that are associated with impaired performance because of using drugs and alcohol whilst on duty. But there are also associated corruption risks with that as well. And so the premise of drug and alcohol testing is one of deterrence. So that people should choose not to engage in this behavior because of the consequences, the likelihood that they'll get found out, they'll have a positive test, and something bad will happen to them. But again, there is often a sort of underlying remedial approach and a supportive approach about offering employee assistance and rehabilitation where appropriate. So in practice, drug and alcohol testing, the testing rate needs to be high enough to provide a high chance of being detected. And officers need to be aware that there is this program. So in order for it to be a deterrent, officers need to understand that they may likely be tested. And there's some good evidence for the success of random drug and alcohol testing from the New South Wales Police in Australia. They're one of the best at putting data out in the public record over a period of time. And they have shown that they used to have problems with officers using drugs and alcohol, but since they increased the rate of their random testing, they now have very few positive tests, which is obviously a good result. So moving on then, the next two strategies are around surveillance. So first of all, covert surveillance. So this is can be the use of things like undercover officers, covert cameras, listening devices, but also a program of targeted and random integrity tests. So similar to the drug and alcohol tests, but this time where officers may be actually presented with a corruption opportunity, and it tests to see whether or not they will take up that opportunity. So the premise again is one of deterrence. But here really the evidence is best supportive for these kinds of techniques to be used in targeted investigations. So where you have a suspicion that something is occurring, there's mixed evidence for the actual deterrent effect of random integrity tests on a widespread scale. So the other form of surveillance being overt surveillance, obviously the use of cameras now has become standard practice, particularly in police cells, police interview rooms, on police vehicles. And there's an emerging practice of using body-worn cameras as well on officers to record their behaviour. So again, the premise here is one of deterrence. So it's about monitoring behaviour of officers as well as the people that they're interacting with. And obviously the captured footage from the video can provide evidence of wrongdoing. And then there needs to be some monitoring of that and some consequences if something is recorded and shown in a recording. And again, there's good evidence in terms of video recording of police interviews, certainly with suspects, that this reduces things like coerced confessions, evidence tampering and fabrication, and those sorts of activities. And there's also emerging evidence around the use of body-worn cameras, particularly around reducing the number of complaints against police by citizens. There's some studies out of the US that have shown quite considerable reductions. But obviously the cameras need to be switched on and switched on sort of mandatorily. And that footage obviously needs to be reviewed so that there are actually some consequences if something is caught on camera. The next one that I'll talk about is substantial external oversight. Now, most agencies, police agencies, will have these days some form of external oversight of their complaints processes and integrity issues, usually in the form of some sort of review function. But really what we're talking about here is a sort of higher level of oversight, if you like, and sort of greater powers. And really it's recommended that oversight agencies should have the power to investigate complaints, to audit data for issues so that they can actually search out and find issues themselves rather than responding to complaints, and have the power to recommend improvements, disciplinary proceedings, and refer criminal matters as well. And so the premise here is one of increasing accountability and related deterrence again. So the idea is that if investigations are independent of the police, this will increase their fairness and thoroughness, or at least the perception of, and that increases the likelihood of actually identifying corruption and responding to it. So that's the deterrent effect. And there's some evidence out of the US that those agencies that do have more power certainly tend to have their recommendations implemented more frequently. But really the police ombudsman for Northern Ireland stands up as an example of an agency that has quite considerable powers and has gained a lot of success in a variety of areas. So things like increased satisfaction of complainants as well as police officers, and improvements in terms of police actions and procedures, as well as reduced complaints. And then finally, finally, stepped up procedures and training. So stepped up being sort of upgraded procedures and training. And this is a little bit of a catch-all in one way. And it's really things that can support advanced integrity systems by upgrading rules and training. And Kelly's presentation next will also give some examples around procedures and training. But the aim here is really about removing opportunities for corruption as well as removing excuses for corruption. And you'll see those sorts of terms used in Kelly's presentation a bit later. So in terms of the rules, it's about setting clear expectations of officers, what's expected of officers, and setting clear consequences of wrongdoing and following through with those consequences. Training is obviously about increasing knowledge and increasing officer performance. But it's also about controls over behaviour as well. So having procedures and rules that, that control various aspects of what police officers can do. And there's some evidence, there's a couple of pieces of evidence here in relation to changes to procedures that have led to reductions in deaths in police custody in England and Wales, and also in terms of police shootings in New York, where substantial changes to monitoring and policies and training and those sorts of things led to really quite substantial reductions around police shootings and fatalities associated with those shootings. So in conclusion then, I've been through a variety, fairly quickly, a variety of strategies that agencies can consider. And so it's really about thinking about what's appropriate to you. Most of these strategies are based around deterrence. So that idea of there being consequences, negative consequences for behaviour. So some sort of threat, so that officers choose not to engage in corruption. But there also is, with many of them, that sort of underlying remedial approach as well, and providing support to officers to try to help and deal with any issues before they escalate to something more serious. It's important to note that agencies might need several strategies. So it's not the case that you can just sort of choose one of these and all your corruption and misconduct problems will go away. You may need several strategies, but it's really about tailoring those strategies. So thinking about the types of problems and the scale of problems that an agency is facing, and then choosing the most appropriate strategies for those problems. And of course, there are challenges to implementing any of these strategies. So it will depend on the resources that an agency has at their disposal, and they may need legislative changes as well to support some of these strategies. And many of them may not be that popular, certainly in the first instance, with police officers, because they do challenge traditional police autonomy and privacy. And even if you do implement strategies, you still need to monitor the problems and the potential for problems long term. So again, it's not a case of implementing a strategy and then sitting back and thinking that you've dealt with the problem, but you do need to consider whether or not the strategy is effective, whether or not problems might pop up again over time. But really, there are benefits of these strategies for all people concerned. So for the police officers themselves, as well as their managers and the general public. So reducing complaints, a better public image, improved safety, as well as a better operational environment, and interventions that are actually geared around officer wellbeing and career advancement as well. So whilst they may not be popular, they can be sold to officers as a positive thing. So thank you very much. As I said, the slides will be available so you can follow up the various references, but I'll hand over now to my colleague, Dr. Kelly Hine from the University of the Sunshine Coast, who's going to talk to you about a situational crime prevention approach to assessing problems and tailoring solutions. So thank you very much, and I'll stop sharing and allow Kelly to share hers.
Thank you. So one of the problems that we have when trying to address or prevent police corruption is that the tactics that we use tend to be time-consuming, complex, and difficult to implement. So I want to talk to you today about an alternative approach that we can apply to police corruption that is more practical and proactive to prevent corruption from occurring in the first place. And that is by taking an environmental approach, which is based on the concepts of opportunity theories. So the idea behind opportunity theories is that the offenders will weigh up their options to make a rational choice about committing a crime. And that crime, or corruption in our case, occurs because the opportunity for the crime to occur exists. So in order to prevent crime or corruption, we simply remove the opportunities for it to occur. Can I just check that you're seeing my slides?
Yes, I can see slides.
So traditional approaches tend to be reactive approaches that are time-consuming, complex, and difficult to implement. And the traditional risk assessment tools that we use can also be complex and difficult. On the other hand, environmental approaches offer a practical, proactive, and targeted approach to understanding and preventing corruption from occurring. Environmental approaches have been successful in addressing a wide range of crime problems, and this is well established within the criminology field. So environmental theories provide a simpler approach because it focuses on the situation rather than the complexities of psychological and social characteristics of criminality. And so in order to prevent crime or corruption, they aim to manipulate the immediate environment. Environmental theories have foundations in rational choice theory, and this subscribes to the notion that individuals will weigh up the costs and benefits of a decision, that they make a rational choice to commit a criminal act, that they choose to do it. And so for a crime to occur, three elements need to converge in time and space. Firstly, there must be a motivated offender. There also needs to be a suitable target, and finally, a suitable place for it to occur. This crime triangle was later adapted to include motivations. So in order for a crime to occur, there must be a suitable target with opportunity available, the ability to acquire this product in a specific place, and the desire on the part of the offender to complete the crime. So to prevent crime from occurring, we can add a handler who can control the offender, or a manager, someone who can control the place, or a capable guardian who can protect the target. While this immediate environment can enable the offender, we also need to consider the situational precipitators that can initiate the deviant behaviour. So why the crime was initiated. So the triangle enables an offender, and the situational precipitators examine why the crime was initiated. And this could be for two main reasons. That of being situationally dependent. For example, the officer committed the deviant act as a response to the situation that they found themselves in, or the officer was already motivated. The officer was proactively seeking out opportunities to engage with corrupt behaviour. And so these two different initiations require very different prevention strategies. So once we have diagnosed what is happening, and we know who our offenders are, what they are targeting, and where it is taking place, and why the corruption is being initiated, then we can tailor a prevention strategy to that particular situation. And we can do this with a range of options provided in the situational crime prevention table. So the latest classification of the table contains 25 different techniques that are grouped into 5 approaches: increase the effort, increase the risk, reduce the rewards, reduce provocations, and remove excuses. Overall, it offers a proactive approach that does not preclude the implementation of other tactics. Additionally, by blocking the opportunities for crime to occur, deviant subcultures may also fail to cultivate. So let's take a look at an example of how this could work. So we were interested in seeing if we could apply environmental theories to understand patterns of police misconduct here in Australia. So we wanted to diagnose what was occurring in Queensland. So to understand what was happening, we looked at substantiated cases of serious misconduct by looking at official documents. These were court transcripts from cases heard at the tribunal. We looked at all relevant cases that were published online. So these were for over a 6-year period. It should be noted that this was an all-inclusive example. It didn't include minor cases or unreported cases. But we wanted to use these cases because it focused on serious matters, and these were reliable cases that had been scrutinised through a number of processes. So let's first take a look at the cases when the officer was motivated by the situation, in that they weren't proactively seeking out opportunities, but were simply reacting to the situation that they found themselves in. So in these types of situations, they were mostly conducted by low-ranking officers for a noble cause, and they tended to be one-off events. They were mostly occurring in entertainment precincts, and the officers were acting alone. And we found that these officers were mostly using physical force to target a person while they were on duty, often with a civilian bystander witnessing the incident. So an example was a male constable who was on duty and arresting a female suspect outside a casino. To make the arrest, the officer used excessive force by pushing the suspect's head into the bonnet of a police vehicle. While the officer's partner was assisting in the arrest, the inappropriate force was only used by the assaulting officer. So again, now that we've diagnosed what is happening in these types of situations, we can tailor prevention techniques accordingly. So in these situations, we could implement suitable handlers to create a positive cultural change against the noble cause intentions. And researchers have found that superiors who do not administer good controls can lead to higher frequencies of inappropriate use of force. These cases typically occur in public where formal supervision can be low, but the likelihood of informal monitoring in the form of civilian witnesses or bystanders is high. Strengthening formal managers and surveillance, such as CCTV in entertainment districts, may increase the risk to these types of offences. Ensuring an easy and accessible complaints management system for the public can help to extend guardianship, particularly when witnessed by fellow officers or civilian bystanders. And we can remove excuses by setting rules that restrict discretionary decisions, alerting the conscious of officers about these rules, and by posting instructions. And we know that if we don't do these things, that excessive use of force can normalise by excuses and justifications. Let's now take a look at the cases where the officer was already motivated, in that they were looking for opportunities to engage with corruption. What we found was that the majority of these matters actually involved these types of cases, officers who were proactively seeking out opportunities. So officers were choosing to engage with misconduct. We discovered that of these proactive types of misconduct, officers were most often engaged in it for personal gain. And these tended to involve multiple matters across multiple events. So this suggests a pattern of ongoing behaviour. So we can start to see where an early intervention system like Louise was talking about might apply here. The place in which these were occurring was most often in police stations or watch houses, and officers were usually acting alone. They were targeting the state or an organisation, and they were doing this by altering official forms or unlawfully accessing police computers. They were mostly on duty at the time with a fellow police officer who is either aware of the situation or is present during the misconduct as a bystander. So an example of proactive misconduct was a case that involved an officer who was facilitating an organised crime gang. The officer was accessing confidential data to provide to members of the crime gang about how much the police knew and when they were going to conduct raids. And he was doing this on multiple occasions at his own station. While there were no other officers involved in the misconduct, there was another officer who suspected the behaviour and informally warned the officer. And so facilitating illegal trade was also the highest ranked concern that participants in that 2019 workshop identified as the most harmful type of police corruption. So now that we've diagnosed what's occurring, we can start to tailor tactics to prevent it from occurring. So according to the crime triangle, in order to prevent crime from occurring, suitable handlers should be utilised to monitor potential offenders. Given that proactive misconduct mostly occurs at the police station via the use of computers, suitable monitoring of this place could be implemented, either electronically or through the roles of suitable personnel. For example, the appointment of a data manager to monitor the place would increase the effort needed to commit misconduct by controlling access to facilities or systems. This would also help to increase the risk by reducing anonymity through requiring officers to formally request information from the data manager. And this point was also raised by the External Oversight Agency, who identified and acknowledged the problem of improper access to databases and recommended officers should provide their reasoning for accessing information and that warnings could be displayed to raise awareness. Now that we have an understanding of who the target is and the opportunity, we can tailor a suitable guardian to this particular problem. For example, implementing an independent auditor as a guardian to monitor the target. This may help to increase the risk and reduce proactive misconduct. Like Louise mentioned, a strong and thorough oversight agency has been found successful in addressing police misconduct. Given that these proactive cases seem to involve a pattern of ongoing behaviour, the role of workplace supervisors could also be utilised to make positive cultural change, particularly against the proactive and personal gain intention. This cultural change may also assist in encouraging fellow officers who are aware of the situation or present at the time to intervene as guardians. And research has shown that superiors who administrate good controls can have a strong effect on the attitudes and behaviours of subordinates. So embedding handlers at high risk who are ethical role models for officers. So you can start to see how environmental approaches can be used to diagnose and describe tailored prevention strategies. So if we go back to the findings from the 2019 workshop and take a look at corruption in terms of facilitating illegal trade, there's been a number of studies that have looked at situational crime prevention in terms of illegal trade more generally. For example, the application of environmental theories have been used to look at corruption more generally, such as financial corruption or corrupt employees. There's also been research on sex trafficking and prostitution, as well as illegal wildlife trades. Specifically, Tunley and colleagues looked at using situational crime prevention to prevent occupational corruption, so corrupt employees. And they identified a number of prevention techniques according to the model that could be used, like increasing the risk and increasing the effort in these first two columns. Here you could use early intervention systems in terms of screening and audits. You could also use early intervention systems in terms of integrity testing and ethics programs. And you could use covert tactics to monitor staff, monitoring their telecommunications like emails, phone calls, web activities, and so on. But there were some commonalities in all of these, like assisting natural surveillance by providing monetary rewards for whistleblowers, reduce anonymity by logging personnel who access data or evidence, and removing excuses by setting rules, making police aware of the laws and objectives, posting clear instructions and procedures, and alerting the conscious by using social marketing and awareness campaigns within the police agency. If we take a look at the type of corruption that was considered the second most harmful, which was external influence, this was the influence by powerful people to obstruct an investigation. Then we can go back to our crime triangle. We could implement suitable handlers to create a positive cultural change. And if we look at our prevention table, we could strengthen formal surveillance, such as oversight agencies, neutralise peer pressure and discourage imitation with the use of suitable supervisors. And again, we can remove excuses by setting rules and alerting the conscious. And in terms of what was considered the third most harmful type of corruption, which was organised police crime, that's a network of police directly involved in trading illicit drugs or other contraband. We can look to a study that was conducted by Eden colleagues who examined police corruption here in Australia to find that corruption was occurring due to a number of opportunities, including poor management practices, lack of poor procedures, failure to store property in the property room, and storage facilities were not secure or had too many staff with access. So here we could use target hardening to establish the minimum standards throughout the police service for the storage of money and other valuables, and access control to reduce the number of officers with access to the storage. We could increase the risk by using surveillance, and this could be done overtly, like Louise was talking about, by using policies that ensure dual responsibility. For example, the need of two signatures or the presence of another officer. And formal surveillance, such as regular checks and stock takes on books. This places the onus for loss upon managers to ensure that they are thoroughly conducted. And again, we can remove excuses by setting clear rules, posting instructions, alerting the conscious, and assisting compliance. And so the point of all this being that you can use data to diagnose what is happening in your jurisdictions by looking at the reason for police corruption to occur and the aspects of the offender, place, and target. And then once we know what is happening, we can use the situational crime prevention table to tailor prevention techniques. And we can use the data to assess its success or if something needs to be altered. So overall, it's about the importance of understanding the problem and then measuring the impact. Thank you.
Sorry, I was on mute. Thank you very much, Dr. Lewis and Dr. Kelly Hine for your insights presentation. And I'm sure that the participants got useful information and inspired by your presentation. Before we move to the next session, please allow me to inform the participants that since we were asked where to get the presentations or the materials mentioned during the presentation. So we will try to gather all presentation slides and make them available on the event website or upload it on the Google Drive. So all of you can access, and we will provide that link to all of you after receiving a permission from the speakers to share their slides. So moving up next, I am delighted to lead you to the second session of corruption prevention in practice. We will hear about the law enforcement integrity strengthening measures from the Asia Pacific region, where we have representatives from Australia and Korea. So please welcome the first speaker, Ms. Leah Ambler. She is the Director of Crime Prevention from the Australian Commission for Law Enforcement Integrity, or ACLEI. So over to you, Leah.
Thank you very much, Kunpa, and good afternoon, good evening, everyone. I'm sharing my screen, so I hope that you can all see it. Firstly, I'd like to start off by thanking the American Bar Association Rule of Law Initiative and the UNODC Office for Southeast Asia and the Pacific for the invitation to present today on Australia's approach to strengthening law enforcement integrity at today's webinar, and also to congratulate ABA Rowley and the UNODC on the launch of the second edition of the Law Enforcement Integrity Checklist and the Toolkit on Police Integrity. Both of these tools are excellent practical guides to help law enforcement agencies to implement concrete measures to prevent and detect corruption. So before I begin my presentation, I'd just like to acknowledge the traditional custodians of the lands from where I'm joining you today, the Wongba clan of the Yuin Nation, and pay my respects to their elders, past, present, and emerging. Today, I'll provide a brief overview of the Australian Commission for Law Enforcement Integrity, which we refer to as ACLI, and I'll outline the role of ACLI in preventing, detecting, and investigating corruption in Australia's federal law enforcement agencies. I'll then present a few case studies to illustrate some of the corruption vulnerabilities that ACLI has identified in its investigations into law enforcement officials, which are also identified in the Southeast Asian typology of corruption, which we've been referring to throughout the webinar today. And I'll conclude with an overview of ACLI's approach to prevention of corruption. So firstly, a quick overview of Australia's anti-corruption framework. As you can see, ACLI is one of several federal agencies which are mandated to prevent, detect, and investigate corruption and strengthen integrity in Australian Commonwealth agencies. In addition, each Australian state and territory has a dedicated integrity or anti-corruption commission, which oversees state-level public or law enforcement agencies. So this is to paint a picture of the framework within which ACLI operates, and a point that I'll come to later in terms of our approach to corruption prevention, which is really to benchmark, share information, and to share good practices. Next, in terms of ACLI's specific role, ACLI is governed by the Law Enforcement Integrity Commissioner Act, which sets out ACLI's powers to investigate serious and systemic corruption in designated Commonwealth agencies with law enforcement functions. ACLI was established in 2006 and originally had jurisdiction over the traditional criminal law enforcement agencies in Australia. That is the Australian Federal Police, the Australian Criminal Intelligence Commission, the Australian Transaction Reports and Analysis Centre, AUSTRAC, which is Australia's financial intelligence unit, the Department of Home Affairs, which encompasses the Australian Border Force, which is Australia's customs agency, and the Department of Agriculture, Water and the Environment, which has specific biosecurity enforcement functions. As of January this year, ACLI's jurisdiction was expanded to cover other federal regulatory agencies, including the Australian Taxation Office, the Australian Competition and Consumer Commission, the Australian Prudential Regulation Authority, and the Australian Securities and Investments Commission. So a shift from the more traditional criminal law enforcement agencies to also covering the law enforcement functions of regulatory agencies. Now, ACLI's 4 core functions are firstly to receive and assess notifications and referrals of alleged corrupt conduct. Secondly, to conduct investigations into serious and systemic corrupt conduct in those agencies. Thirdly, to support those agencies to conduct their own investigations. And finally, to prevent corruption through engagement, support, and identification of vulnerabilities within those agencies. Now, as I mentioned previously, ACLI is an independent agency governed by standalone legislation. So ACLI is one of the external oversight agencies that Dr. Porter referred to in her presentation. The legislation that governs ACLI sets out specific powers of the Integrity Commissioner and obligations for agencies within her jurisdiction. So firstly, agencies are required to notify the Integrity Commissioner of suspected corruption, and the Commissioner can initiate her own investigations independently of any referrals. ACLI can conduct investigations and has a broad range of powers, including covert investigative techniques that can be deployed in ACLI investigations. And the Commissioner can refer evidence to the Commonwealth Director of Public Prosecutions, Australia's public prosecutor, for criminal proceedings. And a number of ACLI investigations have led to criminal convictions and penalties. The Integrity Commissioner can also make her own findings of corrupt conduct and can decide to publish these. And a number of ACLI investigations are available publicly on the ACLI website. So aside from ACLI conducting its own investigations, it can also refer investigations to agencies within its jurisdiction to investigate themselves, or conduct joint investigations. In either case, agencies are required to report back to the Integrity Commissioner on the outcome of those investigations, including potential corruption risks or vulnerabilities that have been identified and measures that have been taken to address those risks. So if we're looking specifically at law enforcement corruption, I've set out here on this slide what I call the perfect storm. Law enforcement is a high-risk operating environment. Law enforcement officials, through their specific functions and roles, are often exposed to or in interaction with organised crime as part of their function, and they're therefore highly susceptible to grooming and manipulation from organised criminals. Law enforcement agencies can also have strong subcultures that create vulnerabilities for group influence, or indeed reach back, which is a term used to describe when law enforcement officials may have left an agency but still have influence over their former colleagues within the agency and seek to exert that influence. And furthermore, corrupt law enforcement officers understand law enforcement methodology and criminal methodology and can therefore conceal their activities, so it can be very difficult to identify. In terms of some specific case studies to illustrate the corruption vulnerabilities that have been identified in the course of ACLI investigations, I've chosen 3 case studies to present today. The first one is from an investigation which was called Operation Ruby, and it illustrates the issue of grooming. So grooming as a concept, I think, to differentiate a little from the illustrations provided by Dr. Hein in her presentation, grooming can find a law enforcement official in a situation where they've inadvertently become exposed to corruption through a personal relationship, and can often only realise the situation that they're in when it's too late. And we do see quite a lot of examples of grooming in ACLI's investigation. So this particular case involved an AFP officer who had released sensitive information to a drug syndicate in return for money. That situation arose when the officer was influenced by a former mentor, a senior officer who had mentored that officer when that officer first joined the Australian Federal Police, who then left the police and introduced that officer to a trainer at a gym. And the trainer had connections with an organised criminal syndicate, nurtured a relationship with the officer, and then solicited information on behalf of their organised crime associates. The trainer passed on a payment to the officer in return for the disclosures that the officer provided. The officer went and accessed AFP information systems to obtain the information that was requested that was not in connection with that officer's functions or roles. And as a result of ACLI's investigation, the officer was convicted of criminal corruption offences, and the Integrity Commissioner made a finding of corrupt conduct, namely abuse of office. So this case study illustrated reach back from former colleagues within a law enforcement agency, grooming, so through the development of this relationship by the trainer at the gym who had criminal associations, and also the underlying issue of unauthorized access to protected information platforms and disclosure. So in response to this investigation and to the vulnerabilities that were identified, ACLI developed a case study on grooming coming out of this investigation, a video for the attention of staff members of law enforcement agencies that highlighted the risks of grooming so that they could be alert to those and manage those risks, and also a fact sheet on grooming, all of which are available on the ACLI website. The second case study is in relation to ACLI Operation Zeus, which involved an Australian Border Force customs officer who had assisted a criminal syndicate by facilitating the importation of undeclared tobacco into Australia. And again, this relationship came about through a former colleague in the Australian Border Force In return for a bribe of $100,000, the ABF officer conducted searches on ABF computer systems and provided information to the criminal syndicate about the customs status of sea cargo containers of illicit tobacco. So this also highlights the corruption risk that was identified in the typology, in the Southeast Asian typology of corruption, of involvement in illicit trade. The case study highlights the exploitation of personal and professional relationships for corrupt ends. And again, this underlying issue of unauthorized access and disclosure. The outcome of this investigation was that the officer was convicted of criminal corruption offences, and there was a finding of corrupt conduct by the Integrity Commissioner. ACLI produced a fact sheet on unauthorized disclosure of information. And in terms of the situational responses that Dr. Hine referred to in her presentation, I think one of the highlights when thinking about unauthorized access and disclosure is being able to monitor accesses to systems, either in a proactive way or through audits to detect and intervene when there are repeat occasions of officers accessing systems when the accesses or the information being accessed is not in relation to the duties which they have been assigned. And then finally, the third case study relates to Operation Adder, which is a case study on social capital. Now, social capital is a concept that illustrates when law enforcement officials may not have a particular financial incentive to engage in corrupt conduct, specifically unauthorized access to information and disclosure, but they may be doing so to leverage personal relationships or their standing in the community. Now, in this investigation, the investigation was commenced following an allegation that a customs officer was using their position to assist in illicit drug importation. The investigation identified the staff member, but did not find any evidence that the staff member was actually assisting in the importation of drugs as alleged. However, it did reveal that the staff member had disclosed protected information to 2 associates. And this was really on the basis of social capital to leverage their standing in the community and to play on their reputation as a law enforcement official and the accesses that they have to privileged information. So in that particular case, the Integrity Commissioner made a corruption finding on the basis of that disclosure, and that they gained social capital for the disclosure. So it's an intangible benefit to that official. In terms of ACLI's approach to corruption prevention, on this slide I've set out the fundamentals of our approach. Our approach is very much evidence-based in that ACLI identifies trends and vulnerabilities from the investigations that it undertakes and from the referrals and notifications that it receives of corrupt conduct. ACLI works with other agencies to find opportunities to strengthen their integrity systems based on the trends that have been identified. And we have a multifaceted approach to prevention. So we target the corruption risks that have been identified by agencies themselves through their own fraud and corruption risk assessments, which they must undertake in accordance with Australian legislation, but also through ACLI investigations. In terms of how we focus our corruption prevention work, we look at the systems and processes that are in place to see if they are fit for purpose and they are achieving the prevention outcomes. So making sure, like I said, that systems audits are in place, that due diligence is being conducted, that conflict of interest declarations are being completed, that gifts and benefits policies and procedures are in place. And we see where there might be gaps or loopholes that could be leading to an increased risk of corruption. And then we also look at the behaviour and the culture, and we look at indicators that might suggest there might be opportunities for corruption, specifically behavioural red flags that might come up in an employment context, so that we can provide advice to agencies so that they can address those. And we also focus on early intervention, as referred to by Dr. Porter in her presentation. So looking at early indicators where there could be a remediation to avoid potential corruption eventuating or an escalation of the situation. We also benchmark national and international integrity standards and practice. So looking to the state and territory integrity agencies, looking to our partner agencies in other countries. And this webinar is an excellent example of international benchmarking. And also proactive sharing of information and good practices across agencies, because one agency may have a corruption incident that would easily replicate or eventuate in the context of another agency, or there could be transfer of risk when employees move between agencies. So information sharing is really key to prevention. We also have specific corruption prevention products. The most successful of these is our corruption prevention community of practice, which meets quarterly and brings together the integrity functions of all of the 9 agencies within ACLI's jurisdiction to discuss collective challenges, solutions, good practices to corruption risks that those agencies are facing. We have a range of communications products, such as the posters on this slide, as well as videos available on the ACLI website. We produce fact sheets on specific corruption typologies or prevention approaches. We also develop classified vulnerabilities briefs, which we deliver to agencies based on what we are seeing through our investigations. And that's more of an intelligence product to help those agencies target their corruption prevention and integrity frameworks. We develop case studies from concluded investigations and finalized court proceedings. And we also have an integrity maturity assessment for law enforcement agencies, which brings together the fundamental principles of a strong corruption prevention framework so that agencies can refer to that when developing their own internal policies and procedures. So that's a brief overview of ACLI and our approach to corruption prevention in practice. I hope it's been useful for all of the participants, and look forward to the discussions throughout the rest of the webinar, and would welcome any questions or comments. And I look forward to hearing the other presenters. So thank you again to the organisers, and enjoy the rest of your day.
Thank you very much, Leah, for your impressive presentation. And if you have any question, please send your question through Q&A box. And you may notice that we don't have any Q&A so far because we don't have any common questions to be answered. So please feel free to send your question through that Q&A box. And apologies for my forgetful to inform you that please allow me to switch positions from being a speaker of the first session to an MC, and I'll carry out the session from now on. Moving up next, our second speaker from the Pacific region is Mr. Jae-ik Chung, an Interpol from the National Central Bureau, or NCB, so the Foreign Affairs Bureau of the Korean National Police Agencies. So please welcome Mr. Chung. Thank you.
Okay, can you hear me?
Yes, we can hear you clearly. Thank you.
Hello, everyone. I'm Inspector Jake Jung. I will present to you Police Integrity Police of Korean National Police Agency. Can you present my presentation, or should I just?
Would you like to share the screen by yourself, or would you like me to control your presentation?
I will present my presentation.
Okay, thank you. Thank you, sir. All right.
So I will present you about the police integrity policy of Korean National Police Agency. I currently work as an Interpol NCB sole officer, and I'm speaking on behalf of Anti-Corruption Task Force of Korean National Police Agency. So the current status of Korean National Police Agency. First, about personnel and duty. Korean National Police Agency consists of total of 140,000 personnel, including 126,000 police officers. So considering that the whole population of Korea is about 50 million. So Korean National Police Agency has a very huge body of law enforcement, and it is a unified national law enforcement in Korea. So our duty of Korean National Police is to secure civil and human rights like people's lives and properties, and to maintain public order by preventing and investigating crimes. To introduce briefly about criminal situation in Korea, annually 1.8 million emergency calls are made, and annually 1.6 million crimes cases are reported.
I'm sorry, but we are still seeing your first presentation. I mean, your first slide. Can you go to your show slide? The button at your bottom of your screen, please.
Can you okay.
Okay. Or we can share your slide.
Okay, can you share my slide for me?
Okay, hold on for a second.
Okay. So next slide, please. Next slide, please. So about the regulation of police power of Korean National Police Agency. So we divided regulation types to two big categories. First one is external regulations, and that means outside the police body, and the second one is internal regulations. About external regulation, there are ACRC, that refers to Anti-Corruption and Civil Rights Commissions, which resides outside of Korean National Police Agency, evaluates integrities of Korean government offices, including Korean National Police Agency, and monitors civil rights infringements. Also, there is National Human Rights Commission, which is called NHRC, watches on human rights infringements by government, including police. And there is also a board of audit and inspection, which periodically audits and inspects on overall police affairs. So internally, to investigate it fairly, Korean National Police is running investigation screening system. In this system, corruption warning incidents, including active or former police-related crimes and vice crimes, are reviewed by independent inspectors. Korean National Police Agency also established a one-strike-out regulation, which restricts appointments of disciplined police officers to crucial posts inside the police body, including investigation, audit, human resources, accounting, vice, and etc. Moreover, prohibition of private contact with concerned persons, regulation of requiring advanced notice when officers make private contacts with former police officers who work in the field of corruption warning enterprises, and prohibition of crime incident internal requests are being applied. Also, to meet the expectation by these people, to meet the expectation by the Korean people, civil anti-corruption experts are hired as anti-corruption officer of police departments. They are called as civil hearing officers, and as of today, there are 102 officers throughout the countries. So as I mentioned earlier, Korean National Police Agency was a unified, huge body of law enforcement. But in 2020, we had a series of reform of the laws regarding the structure of the National Police Agency. So now we do not have the unified body of the police law enforcement. So there is a national police, and separately there are autonomous police law enforcement. So who governs the autonomous police agencies is Autonomous Police Commission, and who governs the National Police Agency is the police commissioners. So according, like in the chart, they are governed by different head of the department, head of the agencies, and also they are monitored by external bodies of outside police law enforcement. Next slide, please. So about the outcome of integrity policy of Korean National Police Agency. With these efforts for last 5 years, bribery cases of police officers of Korea reduced greatly to 26 cases in 2020, dropped from 42 cases in 2016. External evaluations on integrity and trustworthy are also showing good results. According to the Criminal Justice Office Integrity Perception Survey carried out by Korean Institute of Criminology and Justice, Korean National Police earned higher integrity perception than other offices in Korea, like Supreme Court and Supreme Prosecutor's Office. Moreover, according to the integrity survey carried out by Korea Institute of Public Administration, Korean National Police recorded relatively high score than other agencies. Other than that, according to Corruption Perception Index published by Transparency International, Korea ranked 33rd in 2020, jumping from 52nd in 2016. Next slide, please. Next, please. For Korean National Police Agency, 2021 was a very important year. According to Criminal Procedure Code reform, Korean National Police Agency now has the right to conclude investigation and serving people more closely by implementing autonomous police system. If the word is a little bit awkward, you can think of provincial police and local policies. Naturally, people's expectations of police integrity and fairness is getting higher. And to meet these needs, our agency launched Anti-Corruption Council, which is organized with civil experts. Anti-Corruption Council reviewed, after launching Anti-Corruption Council, it has reviewed the police integrity policies of last 10 years. As a result, they pointed out that Korean National Police Agency's police integrity policy had no visible goals and changed frankly from time to time according to the change of leaderships. So that made police integrity policy not sustainable. So council recommended to implement long-term anti-corruption plan. Next slide, please. So to implement a long-term anti-corruption plan, prior to that, we analyzed the 4 causes of corruption. So the first one is frequent opportunity, and second one is high return, and third one is low detectability, and last one is corrupted organizational culture. First, the cause of the first cause is frequent opportunities of corruption. Having more power and discretion expose police officers to corruption. If seduction continues, there is more possibility that officers can be corrupted. Especially, police exercise powerful legal actions against citizens, so officers are often exposed to seduction by suspects, fugitives, and other related people. Second cause is high return of corruption. If the return of the corruption is way higher than the expense, corruption tends to occur. For example, if an officer gains millions of dollars by inappropriate action and punishment worth less than millions of dollars, he will commit corruption. Third cause is low detectability of corruption. If one is not apprehended for his corruption, everyone will tend to do the corruption. Last cause is corrupted organizational culture. In the era of promoting corruption and tolerating corruption, anyone in that organization can be corrupted. Next slide, please. So we introduced 5 principles of anti-corruption policy. First one is to cut off all opportunities of corruption. Second one is heavily punish seducers of corruptions who drag police into corruption. And third one is impose high expense over a return of corruption. And fourth one is don't let the corrupt hide. And the fifth is to promote culture of zero toleration for corruption. Next slide, please. So about the anti-corruption plan of Korean National Police Agency. The long-term anti-corruption vision and goals of Korean police. The vision of Korean National Police Agency is to make a trusted Korean National Police Agency with world-leading integrity. To realize this vision, we set long-term goal as reach ranking number 10th of world integrity in 2032, and short-term goal as a first class of integrity measured by ACRC in 2022. Index of world integrity refers to global corruption barometer suggested by Transparency International. Next slide, please. And about 16 tasks and 4 goals of the long-term anti-corruption implementation plan. In Korea, Korean policies, integrity policy of Korean National Police Agency consists of 4 goals and 16 tasks. Tasks are based on things needed to eradicate the root causes of corruption and to implement sustainable system. Today, I will explain details of 3 important tasks out of 16 tasks. Next slide, please. Key anti-corruption policy. First one is prohibition rule of crime incident related requests. Prohibition rule of crime incident related requests is to forbid all Korean National Police Agency personnel that are not allowed to inquire about crime incidents to each investigator, his colleague, head of the department, and chiefs of police precincts. But official requests, including investigation, cooperation, sharing know-hows are allowed. Persons who are directly related to the crime incident, including suspects, plaintiffs, and others, can also inquire about his incidents. Beginning of this prohibition rule dates back to 2011. At first, it began as a consolidation rule of crime incident related requests and fortified as the principle of prohibition of all internal requests in 2020. Next slide, please. Next, please. And the second one is private contact regulation. Private contact regulations consist of 3 major systems. First system is to regulate, to prohibit, to forbid private contact with illegal enterprises. And the second one is to prohibit a crime incident related people. And last one is to report the private contacts with former police officers. The system of prohibition of illegal enterprises was introduced in 2010, and at first it was to forbid all the relative people of the illegal enterprises, and also make advanced report when they make official contacts with those entrepreneurs. And then in 2015, we modified the systems to not to report when police officers make public and official contacts with the illegal enterprises. And in 2016, we added some more articulations to forbid the contacts when the enterprises are illegal, obviously. So it is obviously. So the list of enterprises that are prohibited from contact are over 5 areas of enterprises, and they are about sex trafficking and illegal entertainment enterprises, and illegal gambling sites, and illegal loan enterprises. Before that, so basically, you cannot contact these illegal enterprises, but when you necessarily have to contact these people, you can just report afterward to the intranet of Korea National Police Agency. So prohibition of crime incident related people was introduced in 2013, and that forbids any contacts with incident related people to investigators and who work at the investigation departments. So the person who related to crime incidents refers to plaintiffs, suspects, and his advocates and other related people. So this system also forbid any contact with the related people, but if you make contact necessarily, then you can report afterwards. Lastly, prohibition of ex-cops, a prohibition of contacts with ex-cops was introduced in 2019. So that is to forbid the private relationship with ex-cop lawyers and law firm personnel and etc. For subjects of prohibition, for example, there are bar and karaoke, massage shop, and casino, something that can be used as the path of corruption. Next slide, please. So lastly, we implemented Internal Corruption Whistleblowing Center. Korean National Police Agency runs Internal Corruption Whistleblowing Center to promote whistleblowing and deter corruption. Internal corruption whistleblowing refers to behavior of any employee of Korean National Police Agency happen to know of corruption, including bribery, embezzlement, unlawful personal affairs, and etc. while reporting to Internal Corruption Whistleblowing Center. Any employee can report corruption to Cyber Korean National Police Agency homepage or via mobile Android app. Whistleblower protection system includes non-disclosure of a whistleblower and alias report and forbidding disadvantages to whistleblowers. When whistleblowing results in profits to the government offices or prevents damages of the offices or augmented integrity very high, whistleblower is rewarded with commendation or prize money. Next slide, please. So this is the end of the presentation, and thank you all for listening to my presentation.
Thank you very much, Mr. Jeong. We did have one question from the audience. about why a funeral service is designated as a corruption worrying business. If you could just help us with that, please. Thank you.
Okay, I will answer to the question because we think when we investigate the unidentified body, and we think there was a public suspicion that police officers can manipulate the cause of the death or gain from information regarding the death. So, well, personally, I think that dates back to the when there was a authoritarian government was established in Korea. There was a lot of demonstrations, and regarding and related to that demonstrations, there were many casualties, and the government didn't want to publicize the death toll or the articles about those deaths, like why they died there. So that is bad news for the government, like their disease from the police overactions. So according to that, police officers were the officers, police officers were assigned to investigate the cause of the unidentified body, but so there's a conflict of interest. So I think that is why the funeral service is dragged into the corruption-related enterprises.
Thanks very much, Mr. Jiang.
Okay, thank you very much, Mr. Zhong, for your informative presentation. And now we have passed halfway through the webinar, and I believe that all of you enjoyed the insightful and comprehensive presentations. And the team received a message from the interpreters requesting a break for a minute or two tops because they would like to go to the bathroom. So please allow me to take a break for 2 minutes, and we will be back. We will be back shortly. Thank you very much. Okay, so welcome back from the break, and I hope you enjoyed the session. Our next session will be the last session of corruption prevention in practice, the session 3 about law enforcement integrity strengthening measures for the Southeast Asia countries. And we will have the representatives from 2 countries, from Thailand and from the Philippines. So let's hear from Thailand first. The first speaker is Associate Professor, Police Lieutenant Colonel Dr. Gritsanapong Putragun. He is an assistant to the president and the chairman of the Faculty of Criminology and Justice Administration of Rangsit University. So Dr. Gritsanapong, the floor is yours.
Thank you very much, Khun Pa. Okay, good morning, good afternoon, good evening, everyone. It is my great honor to be a guest speaker today. I'm going to show you my PowerPoint. Okay, for the presentation, today is strengthening law enforcement integrity authority in Southeast Asia and the Pacific. Actually, I would focus on 5 main issues: police structure, public participation, police training system, transparency, and police reform. I would like to give you a brief background about police structure. According to Police Law 2004, the Royal Thai Police used the idea of centralization in respect of administration. And I can say they use the idea of colonial model. Unlike democratic countries or democratic society, they use the idea of decentralization. Of course, police movement and appointment are based on their superiors' decision. It results in effectiveness of crime prevention and solution. Again, it lacks civilian oversight. If you look at this right, Prime Minister has absolute authority towards the Royal Thai Police. All of these are the organization under the Royal Thai Police. I would like to show you the tripartite structure in democratic model of policing in democratic worlds. Actually, they have central government, police authority, and chief constable. Normally, central governments will look at the training system, the standard of training, forensic research, and so on and so on. And for police authority, they have elected local government officials and unelected local magistrates. They have local plans for crime prevention and solution. And in addition, they have the chief constable to look at the local police operation and crime prevention and public disorder. That is the idea of tripartite structure in democratic world. Back to my point. In democratic society, they favor the idea of policing by consensus. I use this phrase from the British police. On the other hand, in Thailand, it seemed to me they like the idea of policing by superior. Sometimes it may be above the law. And this slide, I'm going to show you the definition of police integrity, like we talk about the ABA Lowry Law Enforcement Integrity Checklist and UNODC checklist, that I had a chance to look at the checklist too. And of course, I think police officer in Thailand define the police integrity differently. More importantly, it involves with social norm and Thai culture, and also police culture too. For example, some believe special fee can be paid to the official to speed up the process, or they can pay the fine on the spot. And politicized policing, excessive use of power, lack of public involvement and inspection. Actually, the law enforcement has been mentioned in constitutional law and other strategies and plans. Like this idea has been put in the 20 years national strategy, national economics and social development plans number 12, or national reform plan, national security policy, and government policies, sustainable development goals, strategy of the Rio Thai police for 20 years. However, it seems that it has not been implemented effectively. According to the World Justice Project report claimed by Thailand Institute of Justice, they show the report of rule of law throughout the globe, and Thailand has been ranked as the 26th from 126 countries. The data were collected more than 120,000 households and 1,800 experts. And an effectiveness of law enforcement has been ranked as 80. You can see from this statistic. Another point that I'm going to present is a police training system at the academy and the police school. In Thailand, the Rio Thai police still favor the idea of the training like a military style, right? Actually, the police work closely with community. They should not be trained like a military. Why I mention this point? Because it results in the police discretion. Each police officer made a decision should be based on the body of knowledge, professional conduct, police morality and ethics, police culture, police integrity, and social norm. However, when they have been trained like a military, it means they have to follow what their superior command. That is the point, and why many senior police managers favor the idea of a military training style. I have two big scandals in Thailand that I'm going to show you. This is the first one. It is Red Bull Air. His name is Warayut Yuvittaya. He was arrested in September 2012 after his black Ferrari crashed into a motorcycle driven by police senior Sergeant Major Ritchie at his speed at around 177 kilometers an hour, dragging his body 100 meters down Sukhumvit Road. It happened in Bangkok. During that time, the forensic police and in cooperation with physics expert from Chulalongkorn University went to the crime scenes, and they look at the crime scene and they decide how speed the driver drove the car. And at the end, they realized the speed would be more than 100 kilometers an hour. It means the driver drove like a legless driving, and he was charged with this accusation, and more accusation have been made with this person. However, last year it's had an interesting story, because there were some former senior police manager working with academia to change the car speed from more than 100 kilometers an hour to less than 80 kilometers an hour. And after that, after the car speed was changed, Prime Minister Prayut said to the public, I'm not okay with handling the case of this Red Bull Air. And then after that, the police who are in charge of this case changed the decision again. I show you this case because the forensics police who is in charge of this case talked to the media. He was requested by the former National Police Commissioner to change the car speed. You can see the interesting story, right? And of course, the media pay more attention on this case. And it's a big question towards me. Police reform or criminal justice system reform. And another scandal just recently, last week, this guy was the head of local police station at Nakhon Sawan province. He was accused of torturing and killing drug dealer. Actually, the drug dealer was the suspect, and the suspect was arrested and brought to his local police station. You can see on the picture on the top left that this colonel tortured the suspects, and there were around 6 or 7 police officers at local police station at that crime scene. And he was accused of corruption, police corruption. Interestingly, before this case happened, he occupied many supercars and luxury houses. Actually, his salary would be around 44,000 baht. It costs around $1,500 US. And why he can have many supercars or luxury houses. And this slide shows the vehicles that he confiscated, like a supercar. He confiscated around nearly 400, and he could earn 25% for arrest. Another interesting story, it happened in the US. I think most of us would know about this case, George Floyd, right? This officer knelt on Floyd's neck over 9 minutes. And Floyd was handcuffed and lying face down. It caused him death. I show you this interesting story in the US because I'm going to show you the next slide. After George Floyd case happened, more and more people went to the street and demand for justice. However, the former President Donald Trump announced to the public the police chief in each state had to control the situation. Otherwise, I will use the National Guards to control the riots, right? Nonetheless, more and more protesters went to the street. And this Houston police chief responded to the former president of the US. He said, please keep your mouth shut if you can't be constructive. My point is, in Thailand, the National Police Commissioner is not allowed to talk to the Prime Minister, right, this guy, or even the head of provincial police region, because of the police law 2004, right? So you can see the link between politics and the police. And if we talk about the police integrity, we need to talk about integrity in political system too. I had a good chance to visit a local police station in the US, and it made me so impressive about 3 words at the local police station. You can see, right? Honor, service, and integrity. And when I came back to Thailand at the police station, it said, I translated it in on the screen, police station for the publics. What does it mean? Police station for the publics. And it has this motto, every police station throughout the country. For the UK, for British police, they have some officer who made illegally, who break the law. You can see on this screen. The former Scotland Yard officer were arrested as part of an investigation into allegations. If we compare this case to police misconduct in Thailand, I think it's a big difference. And I was invited by Home Team Academy to visit them in Singapore. I gave them the photo of King Rama V and King Rama IX. And they asked me, and they said to me, sorry, they said, oh, may have to report the gift that I got to my superior. You can see how they prevent the corruption. Actually, in Thailand, there are the organizations who deal with police corruption. Nonetheless, it seems that many police misconduct cases have not been inspected vigorously, in my opinion. However, public movement and social media would be powerful tools to track and stop corruption. It means that in Thailand, it does not have the concrete mechanism to prevent police corruption. Of course, when we talk about the police integrity, we need to talk about the police reform. But my question is, only the police should be reformed, or we need to reform criminal justice system as a whole, right? How about democratic model of policing, legitimacy, accountability, decentralization, transparency, public participation, and professional conduct? Code of ethics and professional conduct to training system need to be made. And it need to have external oversight to inspect police misconduct. And an independent police complaint commission need to be set up, maybe at national or even regional level. To strengthen law enforcement integrity, policy formation and implementation need to be clear from the top to the bottom. Police training at the academy and in-service training need to be adjusted like a modern policing, not military style. Public should be involved in routine policing activity. Prevention and inspection mechanism should be done seriously, and particularly those regarding suppression and punishment the officer who committed like a corruption need to be punished seriously, just to stop the other police officer corrupt. This infographic show the timeline of police reform in Thailand. You can see on the top left of the picture of this infographics. In 2014, the military state a coup, right? And they announced to the public they are going to reform the force. And then after that, until now, 2021, in Thailand, is still request for police reform. That is the end of my presentation. Thank you very much.
ขอบคุณค่ะ Thank you very much อาจารย์โต้งนะคะ or Dr. กฤษณพงษ์ภูตระกูลค่ะ Moving up next, we have another speaker from Thailand. His name is Mr. Nirut Suphoka, and he is a legal divisional director from the Bureau of Legal Affairs of the Office of National Anti-Corruption Commission of Thailand. So, Kun Nirut, over to you.
ครับขอบคุณครับท่านทีมผู้จัดงานที่ได้เชิ
Thank
ญ
you,
ทาง
the organizer, for inviting Office of National Anti-Corruption Commission. I'm the Director of Legal Division attached to the Office of National Anti-Corruption Commission. I would like to speak very briefly from two angles of anti-corruption and the suppression of corruption. And then I will touch on police work that the previous speaker talked about police reform, but I will touch upon another angle by allowing the Royal Thai Police to engage in prevention and suppression of corruption. As an agency responsible for enforcing the law together with NACC in anti-corruption work in terms of policy of NACC, which is a policy of anti-corruption commission, in working together with the Royal Thai Police, NACC adopt the strategy in inspecting the police work, in upholding the justice, which is the intention of the Secretary General of NACC to assess the integrity and reliability and transparency of the work. We already carry out assessment of more than 8,000 units. And also the Royal Thai Police, we carry out assessment as well. And our own system, which is called ITA, will do the assessment. The format of assessment of ethics and transparency of work, we will apply IT technology by asking officers in respective units or those who are involved to fill in the information in conducting the survey, in giving scores, in enforcing the law by the Royal Thai Police, which is a part of a proactive strategy in preventing and suppressing corruption in order to upgrade the work, the task of the Royal Thai Police, who have an important role in suppressing corruption. And another tool to assist the work of the police are the police investigators, the supreme law of NACC or the acts. The NACC will have power and responsibility to suppress corruption. And we receive a lot of complaints. It is necessary to have other units, investigating units, to engage in our work in matters that are not that serious. Allegation against a certain level of government officials or lower ranking officials, we will assign the said matters to this agency. Currently, NACC, once we receive complaints, we will refer the matters that we had selected that are not that urgent or not that serious, and does not have much impact to the country, or it does not involve large sum of money. We refer the matter to police investigators to carry out joint investigation as well. So this is another role of the police or the police investigator to engage into the work of NACC. And currently, in the last few days, NACC also came up with different forms of work in order to monitor the works of the police involving in several cases. Once the police have completed their investigation case, if they arrest the suspect, then we will refer the report based on the police investigator to NACC. This is another important role of NACC in working together with the police in an integrated manner. On 23rd of July 2021, NACC conclude an MOU between NACC and the Royal Thai Police in order to coordinate on several dimensions so that our work can be carried out in an integrated manner, whether in law enforcement or coordinating in record of information by relying on IT technology, or coordinating in personnel development, both in terms of NACC personnel and personnel of the Royal Thai Police, in order to work together in suppression of corruption. And the said MOU would provide budget support that certain tasks that have to be carried out by police or by NACC. And both agencies are law enforcement agencies. In suppressing corruption, we believe that in working together in suppressing corruption and preventing corruption, it is necessary to work in an integrated manner from several units. This is the overall situation of NACC and the Royal Thai Police. Thank you.
Thank you very much, Mr. Nirut, for your presentation. And this is the lesson learned from Thailand. And I hope that you will be inspired by the presentation for both the academic side from Dr. Krishnapong Putrakul and also from the ONACC about the integration of collaboration between the Thai police and also the anti-corruption agencies that try to strengthen the mechanism to assess the corruption risk. Okay, moving up next, we have the representative from the Philippines. Please welcome Mr. Manuel Soriano, a Deputy Special Prosecutor from Office of the Ombudsman, and Attorney Nichanee Cabras, Assistant Ombudsman from the Office of the Ombudsman, as they will present about the law enforcement, the corruption prevention from the Philippines. So the floor is yours, sir.
A pleasant day to everyone. I will be presenting some updates on the work of the Office of the Ombudsman in promoting integrity and preventing graft and corruption in the law enforcement agencies in the Philippines. I would like to seek the assistance of the organizers regarding my slides, please. Okay. Next slide, please. In the Philippines, the leading law enforcement agencies are the Philippine National Police and the National Bureau of Investigation. Other law enforcement entities include Philippine Drug Enforcement Agency, Bureau of Immigration and Deportation, the Armed Forces of the Philippines. That is when they are called upon to suppress lawless violence. The indispensable role of the law enforcement agencies in the society calls for an oversight institution like the Office of the Ombudsman to hold corrupt law enforcement officers accountable for their unlawful conduct and correspondingly design programs to instill integrity in the sector, thereby reducing incidents of corruption. Next slide, please. By way of an update, we wish to share with you that this year our courts decided two important anti-corruption cases investigated and prosecuted by the Office of the Ombudsman. One is the case of General Carlos Garcia, a former military controller. He was investigated and charged in the Philippines uh, by the charged in the Philippines before the Sandigan Bayan, which is the special anti-graft court of the Philippines, for amassing millions of pesos of ill-gotten wealth while in active service in the military. After some time, he entered into a plea bargaining agreement with the Office of the Special Prosecutor, Office of the Ombudsman, by entering pleas of guilty to the indirect bribery and facilitating money laundering. Next slide, please. General Garcia offered and eventually transferred to the Philippine government more than 134 million pesos, which is approximately 2.7 million US dollars worth of cash, real and personal properties owned by him and his family. The Sandigan Bayan approved the plea bargaining agreement this year. The Sandigan Bayan approved the plea bargaining agreement, and this year, 2021, the Philippine Supreme Court affirmed the plea bargaining agreement. Next slide, please. The other case is that of General Jacinto Ligot, also a former military controller. The Office of the Ombudsman filed a forfeiture case before the Sandigan Bayan for amassing wealth grossly disproportionate to his lawful income. After due proceedings, the Sandigan Bayan ordered this year, 2021, the forfeiture of certain properties of General Ligot amounting to more than 402 million pesos or approximately 8 million US dollars in favor of the Republic of the Philippines. General Ligot has a pending motion for reconsideration before the Sandigan Bayan. Next slide, please. On another note, an alleged unlawful scheme known as the Pastillas Scheme in the Bureau of Immigration and Deportation came to light during a Philippine Senate investigation in February 2020. Certain immigration officers allegedly allowed Chinese nationals who paid and availed of VIP services to enter into the country seamlessly without going through the regular immigration process. The amount paid was distributed among the immigration officers involved. The investigation led to the filing of complaint against the involved immigration people who were immediately placed under preventive suspension by the Office of the Ombudsman for 6 years. The Ombudsman's preliminary investigation, as well as the Philippine Department of Justice's own administrative proceedings, are ongoing. As an Ombudsman's office which works on promoting integrity in public service, the effects of these kinds of investigation go beyond addressing corruption concerns but extend towards issues of national security, human trafficking, or securing the nation from possible illegal offshore businesses, among others. More relevant today is the Bureau of Immigration being at the forefront of ensuring that travelers to and from the Philippines will not contribute to the further spread of the COVID-19 in and outside of the country. Next slide, please. As part of the Ombudsman's Office initiative and in order not to unduly delay the arraignment and trial of an accused either before the Sandigan Bayan or the regular courts amidst the pandemic, the office allowed its prosecutors to attend the said proceedings through remote hearing or video conferencing, a measure adopted in light of the limitations and difficulties of the litigants in the presentation of their evidence in court brought about by the current health emergency. The prosecutors of the Office of the Ombudsman have transitioned in court to remote trial or hearing. Next slide, please. At the other side of the work is the corruption prevention. As we have reported in our previous presentation in Thailand, the Office of the Ombudsman conducts a program called the Integrity, Transparency, and Accountability in Public Service, or ITAPS. It is a training program with the main goal of helping participants recognize the scope of their responsibility and accountability as public servants, guided by the established relevant laws of the Philippines. For the law enforcement agencies, The employees from the Muleo of the Office of the Ombudsman are the ones providing trainings to specialize the process. Adapting to the challenges of heightened health protocols and distancing amidst the health crisis, the office issued a directive to transition ITAPs to e-ITAPs or electronic ITAPs, whereby the conduct of trainings and related activities will be delivered virtually. The ITAPs has long been has also been redesigned from the one-day face-to-face modules to three-day e-learning modality in 2021, June 2021, after the training specialists and assistants from the National Integrity Center, which is the office training arm, have been capacitated by International Development Law Organization in developing, designing, and delivering effective blended learning activities in April 2021. Next slide, please. A content analysis conducted on ombudsman cases involving police and drug enforcement officers, which were already decided by the Sandigan Bayan and appellate courts, has been initiated by the officers of Muleo of the Office of the Ombudsman. It is aimed at providing useful insights for the Ombudsman's officials and employees to gain a deeper understanding of the schemes of corruptions and plan relevant intervention to address corruption and abuses at the Philippine National Police and the Philippine Drug Enforcement Agency. Review of court cases, which are available online through the websites of the Sandigan Bayan and the appellate courts, has been done in fulfillment of the research. The Muleo study is aimed at coming up with a ready reference in matters such as aiding investigation in terms of essentiality and completeness of information or documents to substantiate the charges, and assisting handling lawyers in the preparation of decisions, resolutions, informations, and prosecution arguments. Given the practicality of the aim of the research paper, it hopefully can be remodeled or modeled in documenting and digesting other ombudsman cases outside of the law enforcement agencies. Should this come to fruition, it will be a pragmatic guide for case handling officers, which would be passed on to incoming officials and officers for continuity of knowledge in cases of staff turnover or new recruitments. This would be a good way to document important knowledge by the office gained over the years of investigating and prosecuting cases. Next slide, please. By way of a concluding note, the most difficult corruption to address is the one that is deep-seated, as it would take more than system changes, but also an assessment and understanding of an institution's vulnerabilities, mindset, and its people's moral backbone. An anti-corruption institution, an investigating and prosecuting agency at that, like the Office of the Ombudsman, cannot be always on the hard side, flashing its teeth and waving its lash. Although punitive side is material, it becomes a repeating cycle without prevention. Much like how a deeply rooted tree regrow branches, corruption persists and emerges in varying forms when there is no uprooting. It is true for all corruption-prone agencies, much so for the law enforcement. The taxing and sometimes frustrating battle to weed out corruption in the law enforcement should be guided by a conviction that corruption should not thrive in agencies that is supposed to enforce the law. That ends my presentation. Thank you very much for the opportunity to share with you some updates on the work of the Office of the Ombudsman. Thank you.
Okay, so next, may I invite Ms. Cabras to do the presentation? Thank you.
Thank you very much, Par. I will share my screen. So on behalf of the Office of the Ombudsman, I would like to thank the organizers for this kind invitation And I have been tasked to give updates on the topic which I presented 2 years ago in Thailand. And I noticed that from the presentations of all the other speakers, the discussion was on strengthening integrity in law enforcement in general, and there was no focus whatsoever on the gender aspect or the role of women, especially women in law enforcement. And that's why this afternoon, I shall be giving updates on the status, prospects, and protection of Filipino women in law enforcement agencies towards achieving gender parity through legislative action. Okay, now, on your screen, you will see the Global Gender Gap Index. Now, what is the Global Gender Gap Index? It is a measure for gender equality based on the relative gaps between women and men in 4 key areas, particularly health, education, economy, and politics. Now, as you can see, the Philippines dropped among the 10 top countries in the World Economic Forum's Global Gender Gap Index, a position that it consistently held from 2006 to 2018. But fortunately, it still remains the top performing country in Asia and second best in the whole East Asia and Pacific region after New Zealand, according to the latest report. And the country's continuing efforts to reduce this gender gap or disparity are manifested in the prevailing statistics in relation to gender participation in governance and law enforcement. Now, let's look at the affirmative action by the numbers. Out of all the elected officials in the Philippine government, 23% are women and 77% rather are men. Career staff in the government, 55% are women and 45% are men. And those in the career executive service, which is middle management to top management, 42% are women and 58% are men. However, for those in law enforcement, these are the numbers. Okay, for commissioned officers, only 16.34% are women as compared to 83.66% for their male counterparts. For the non-commissioned officers, there is slightly higher. This 34,591 or 18% as compared to 81.97% for men. And with this, and the ever-increasing presence of women in politics and governance, civil service, including, of course, as I've mentioned, in the military and law enforcement, taking into consideration the fact that nowadays, Filipino women can already enter the Philippine National Police Academy and the Philippine Military Academy, which are the two premier institutions, training and academic institutions for those in law enforcement and the military. And take note also, we're glad to note that the valedictorian for the 2020 class in the Philippine National Academy is female, even though there were only 83 women who graduated. And in the Philippine Military Academy, on the other hand, while only 34 were women, 5 of the female cadets made it to the top 10, including the class valedictorian again. Okay, and because of this presence, because of their entry into law enforcement, which is traditionally a male.
Attorney Cabras, could you move
Yes?
your slides, please? We're still seeing the first slide. Thank you.
Okay. For a while, I'm just going to check. Okay. So with that, again, since these are traditionally male-dominated institutions and workplaces, one of the problems would be sexual harassment or gender-based abuse and discrimination, especially in relation to opportunities for training and advancement in such traditionally male-dominated fields. So right now, we have one of the key pieces of legislation that the Philippine legislature has enacted, that would be Republic Act number 11313, or the Safe Spaces Act. It was signed into law on April 17, 2019, and it penalizes actions such as catcalling, wolf whistling, misogynistic and homophobic or transphobic slurs, sexist remarks, and unwanted sexual advances, and other forms of sexual harassment in public places, workplaces, schools, as well as in online spaces. This does not supersede, however, the original Anti-Sexual Harassment Act of 1995, or Republic Act number 7877. Rather, the safe spaces were expanded to include the public domain, such as online, okay, because of the prevalence of the our interaction in, online. And before, the 1995 law only covered work, educational, as well as training facilities. And the offenses under the Safe Spaces Act can also intersect other laws, such as, of course, the Anti-Sexual Harassment Law and the Anti-Violence Against Women and Children Act, as well as other provisions which seek to protect women from gender-based discrimination and abuses. Now, in relation to mainstreaming GAD strategies as well as innovations, of course, we still have the GAD budget policy impact, wherein a certain percentage of government agencies' budget is, of course, required to be used for programs that tend to mainstream gender and development. And for this, the Philippine Commission on Women, which is the primary institution which is in charge of mainstreaming GAD, the said commission actually came up with a lot of innovations despite the pandemic. Of course, second, it came up with the compendium of indicators for monitoring and evaluation of gender equality and women's empowerment. And this seeks to prioritize GAD indicators to serve the specific as well as the varying needs for development planning, policy making, programming, implementation, as well as M&E or monitoring and evaluation. And it is intended to serve as a reference for practitioners, advocates, donors, researchers, and policymakers. This was done in collaboration with a lot of our developmental partners. Third, the Philippine Commission on Women also forged a partnership agreement with the Philippine National Police to provide proactive technical assistance to the Philippine National Police focal system, again, for gender mainstreaming. And the two bodies agreed to jointly conduct different activities and programs, including gender analysis and training of trainers. It is also interesting to note that the Commission works closely with the Office of the Presidential Advisor on the peace process, the Department of National Defense, the Armed Forces of the Philippines, the Philippine Air Force, the Philippine Army, and the Philippine Navy, also on GAD-related matters. And then finally, the Commission continues to advocate the adoption of the so-called Women's Priority Legislative Agenda. And this is a set of proposed subjects of bills developed through public consultation that seeks to amend or repeal the discriminatory provisions of our existing laws and pushes for the formulation and adoption of new legislation that, number one, promotes, then second, protects, and fulfill women's rights and empowerment. Now, what about gender and corruption? What about integrity in the public service, particularly for women in law enforcement? Are women really less corrupt than men? Now, let me give you some of the statistics that we have at the Office of the Ombudsman. From 1995 to 2020, a total of 2,350 criminal complaints filed against members of the Philippine National Police and resolved by the office had around 7,800 respondents. And out of this number, approximately 10% or around 780 are female respondents. So only 10% of the respondents in the criminal complaints filed and resolved in the Office of the Ombudsman have women members of the Philippine National Police as respondents. Now, second, as to administrative complaints, our data shows that the Office of the Ombudsman have resolved 2,670 cases against personnel of the Philippine National Police, resulting in 102 respondents. And of this number, less than 8%, or approximately 648, are female. Now, these numbers, of course, do not necessarily mean that women are less prone to commit corruption as compared to men. In fact, it may even be due to the fact that the police service is still largely male-dominated, based on the statistics which I have shown earlier. Nevertheless, it can be surmised from this data that while women are still more vulnerable to the effects of corruption, being a marginalized sector, those who are in law enforcement still seem to be more immune than their male counterparts, especially in terms of involvement in systemic corruption. It must be noted that most of the cases filed against the criminal complaints filed against female members of the Philippine National Police would be in relation to procurement activities, and not necessarily the same cases as filed against their male counterparts. And as for the administrative complaints, some of the cases of which they are respondents would be considered as personal in nature, such as misconduct due to having affairs with their married members of the police personnel, having affairs or being involved in such. So it is not systemic corruption. And thus, in conclusion, in order to ensure that women in the public service, particularly in law enforcement, are protected from gender-based discrimination, abuse, harassment, and to enable them, of course, to continue to be positive agents for change in their respective institutions, it is hoped that all governments, not just the Philippines, will strive to empower them through proactive and protective legislation and innovations that would address the gender aspects of corruption. And that concludes my presentation. Thank you.
Thank you very much for your insights presentation from the Office of the Ombudsman. And we will keep the Q&A session at the last of this webinar after Mr. Francesco Ghecchi's presentation, since we are a bit delayed from the planned schedule, which I'm sorry for that. So moving up next, we have Mr. Peter Ritchie, the Regional Anti-Corruption Advisor from ABA Rule of Law Initiative, to present on Police Integrity Resources, the second editions of the Law Enforcement Checklist. Integrity checklist. So, Kun Peter, the floor is yours.
Thanks very much, Kunpa. I just want to provide a brief update building on Kunpa's earlier work, mentioning that the first ASEAN regional workshop in 2019 produced the law enforcement integrity checklist, some suggestions to review and improve the checklist, including to deal with human rights issues, gender equity, and also technology. So rather than take you through the checklist myself, I'll just quickly, and to save a little bit of time, I'll show you a few minutes of a video about the checklist. And after this session, we will send you everyone who's registered a copy of the checklist and a copy of the video. So here is just a few minutes of the promotional material for the checklist. Oops.
Welcome to this accompanying video to the Law Enforcement Integrity Self-Assessment Checklist.
I'm afraid there seems to be a problem with the technology here. In that case, probably what the best thing I can do is to skip the video, and to save time, send you material on a copy of the checklist and the videos separately. So we can probably move directly to Francesco's session. Thank you, Kunpa.
Okay, thank you very much, Peter. And as Peter mentioned earlier, that this link of the video of the law enforcement integrity checklist will be shared with all of you later after this session. So moving up next, we have the last session of the day. I would like to invite Mr. Francesco Ghecchi, the anti-corruption advisor from UNODC Regional Office for Southeast Asia and the Pacific, to present about the future opportunities of law enforcement integrity cooperation in the Asia and Pacific region, and also UNODC tools and resources. So Francesco, the floor is yours.
Thank you very much, Kumpar. Do you hear me well?
Yes, we can hear you clearly.
Great. Thanks a lot. I mean, first of all, I must say this was just to wrap up. Really, this was an impressive lineup of speakers. And on behalf of the UN Office on Drug and Crimes, I would like to thank, first of all, the American Bar Association for organizing the event with us, but also, of course, our donors, the Korean Minister of Justice and the US government, the State Department as well, for supporting the initiative. Look, the various ways, technical ways to improve police integrity and enhance prevention of corruption have been debated already quite extensively. So I would just like to wrap up with some observation from our side. First of all, how does corruption in police looks like in the region? Several speakers have presented cases, but what are the particular elements that we see? If we look at some of the cases, what stands out really is that in many instances we are dealing with networks of corrupt officials that are in a way related to common or organized criminals as well. For example, in a very recent case here in Thailand, a high-ranking official has been arrested for killing a suspect allegedly to extort a bribe, together with a group of other officials. But the thing that I find most interesting is that he was able to seize hundreds of cars, reportedly earning about 12 million US dollars through his office, so earning personally this amount of money. So these are impressive schemes, fraud and corruption schemes. We have an increasing number of these high-profile cases in the region, and this may be a good indication that the law enforcement authorities are actually working, including former police chief in the Philippines accused of profiteering from drug seizures. We have seen also the cases presented by Mr. Soriano that are quite telling, but we also have senior immigration officers charged with human trafficking in Malaysia, for example, in Thailand, other high-ranking officials accused of embezzling funds and so on. So as I said, obviously here you have schemes involving several officials in various departments and other agencies. These are rarely the actions of a few or a single person. Therefore, there is a need to establish special procedures to address these cases as really what they are, which are in many instances, they are forms of organized crime. From this perspective, it is also extremely important to note the relation between corruption in police and other forms of transnational organized crime. For example, we have recently conducted a regional study on the relationship between human trafficking and smuggling of migrants and corruption. So the study found out that bribery of law enforcement officials appears to be a common part of the modus operandi of many smuggling and trafficking ventures. While such as officials rarely seem to be directly involved in smuggling or trafficking, the taking of bribes from offenders in return for turning a blind eye to illicit activities is widely reported. In some cases, law enforcement officials may also be bribed to provide information on police raids, drop ongoing investigation, or ensure that victims of trafficking cannot escape places of exploitation. So arguably, this can be said about all other forms of transnational organized crime. There are examples of bribery of border police to facilitate the smuggling of weapons that were then utilized for terrorist attacks, and even to allow terrorists to move around in the region. And also, of course, the issue of corruption facilitating drug trafficking. So the UN Convention Against Corruption requires state parties to introduce a set of measures to promote integrity and prevent corruption within national public administration, including law enforcement agencies. These include measures for preventing nepotism and favoritism in the appointment, promotion, and dismissal of public officials, the development of specialized training for the positions that are particularly prone to corruption, but also the development of code of conduct, asset declaration system, conflict of interest frameworks, and so on, that we have discussed during the website, the webinar. The convention, also beside this necessity of improving oversight mechanism, both disciplinary and criminal, as well as internal and external, in my opinion, there are a few issues that really stands out from the webinar. First of all, the problem of whistleblower protection. So reporting corruption is dangerous in general. It becomes extremely dangerous when it comes to police corruption, both internally through the internal reporting mechanisms, as well as by external members of the public, to the anti-corruption authorities or other oversight bodies. Our analysis shows that not enough attention is given to the issue of whistleblower protection in the region overall. It is not by chance that the UN state parties at the UN General Assembly special session on corruption held earlier this year highlighted the need to provide safe and enabling environment to those who expose, report, and fight corruption. Also, another issue that I would like to highlight, as mentioned by Dr. Port and Dr. Hein, is the performance of risk assessment and the need to shift from a reactive to a proactive oversight. Oversight agencies are indeed well positioned to identify problems and corruption patterns, utilizing information from complaints, investigation, audits, to create databases that enable the identification of patterns of corruption and crime. I cannot stress enough how important it is for police department to develop all-encompassing strategies to address corruption and intervene strategically there where is needed. Another issue that has to be stressed is the need of independence of oversight. Some of our studies and the cases we have seen highlight the fact that oversight systems, both internal and external, are often not independent enough. They are subject to influence by powerful officials that ends in obstruction of internal investigations. So abuse of power and undue influence are unfortunately quite common in the region. And finally, and I would like to thank Mrs. Cabras for her presentation on this, the issue of gender and overall diversity in police department. It is obvious and well documented that peer-to-peer control among police officers increases when all in our societies are included in the police forces. In particular, it's important to note that the percentage of women in police forces in the region is still very much below average in OECD countries, just to have a comparison. So this is an issue that has to be addressed not only from the perspective of effectiveness of police forces, but also for addressing corruption and improving integrity overall. So in terms, given all these issues, in terms of our work in the region, as explained by Kumpar and Peter from ABA, we have embarked together with them in the organization of a series of events of police integrities in order to identify vulnerabilities and risks, but also looking at the necessity of establishing cooperation among law enforcement authorities to address the issues and the need to identify and promote best practices. So going forward, we think we have an opportunity here to build on the existing network of anti-corruption agencies and law enforcement authorities to develop a framework for cooperation specifically dedicated to addressing corruption in police, mostly to preventive means and improving integrity and ethics frameworks. So the plan is to develop a police integrity network in Southeast Asia, also involving other countries, Australia for sure, if they would like to join, but also Korea. And I would like to thank again the Ministry of Justice of Korea for supporting our initiatives, but also other countries such as Japan and others may be interested in joining. And the objective of this police integrity network would be to raise awareness among law enforcement authorities about the most common and harmful forms of law enforcement corruption, to encourage a commitment for reform in the ASEAN region by improving the understanding of the key elements of law enforcement integrity systems, to further refine diagnostic tools, such as the integrity checklist that Peter and Kumpar discussed, with enhanced indicators covering the nexus between police corruption and also, among other, exclusion, disadvantaged groups, women, sectoral risks such as drug trafficking, trafficked persons, and so on. And in general, to serve as a platform to discuss multilateral support for individual countries who express their interest in receiving technical assistance to review their integrity systems. So we are going to discuss with all interested parties this new network, these frameworks in 2022. We will reach out to your agencies to make sure we have high-level participation and we can agree on the governance and secretariat functions for this network. So we really have high expectation from, I would say, all of you that participated in this discussion, but generally from the law enforcement authorities in the region to really be able to move forward with initiatives that are effective in preventing this corruption, which is reportedly extremely high and problematic. You will hear more from me and from also our colleagues at ABA on this initiative soon. We have registered also your email addresses, so I think you don't mind if we reach out to some of you that are in this mailing list with more information and requests regarding these activities. I also wanted to mention that UNODC has also developed a toolkit on prevention of corruption and improving integrity and accountability in police department. I will post the link to this toolkit in the chat box, so you will have it available. This said, thank you very much for the discussion. Again, thanks a lot to all the panelists. It was really extremely interesting, and I will give back the floor to Kumpar for the closing of the event. Thank you.
Okay, ciao. Thank you very much, Francesco, for the presentation. And now that we running out of time, so I would like to invite all of you to please scan the QR code of the evaluation form, and we will do the survey, the evaluation during the Q&A, as I promised that I will keep the Q&A sessions at the last. So the team also share the link through chat box for those of you who might not attend this webinar by using the PC or laptop. You can just click on the link in the chat box to take surveys. So I will hand over back to Peter Ritchie, and he will take care of the Q&A session. So back to you, Peter.
Thanks very much, Gunpa. We just have time while people are doing the evaluation for a couple of questions, and I'd invite any of our speakers to respond to the questions. The first one is there any experience of the effectiveness of offering cash rewards for people who report misconduct or corruption? Do we have a taker from one of our panelists to answer that question? While you're thinking about that, the second question is how to deal with systemic corruption involving higher levels of a police service. And while potential respondents are thinking about that second question, I'll give my own perspective on the second question about senior levels of police corruption. And quite often the case is that this kind of vertically integrated criminal enterprise. And what does that mean? That people at lower ranks who are taking and receiving bribes need to funnel a share of the bribes up through the organization to the senior ranks. And in Southeast Asia, we've heard examples of people needing to pay large amounts of money for promotions at certain police posts. So part of the answer possibly would be to look at mid-ranking and senior police as politically exposed persons under national anti-money laundering legislation, and to monitor their financial affairs, and also to have income and asset disclosures. But it'd be nice to hear from our other speakers about the question of cash rewards or senior level corruption. Any takers there?
Peter, maybe I can say a few words here. I think the issue is really delicate, because in some instances, rewards for whistleblowers, people that report corruption, have proven effective. I mean, not particularly on police corruption. What I know, for instance, is the framework of the Foreign Corrupt Practice Act, where the Department of Justice of the United States provides rewards to informants of corruption cases, foreign bribery, mostly corruption cases, that results in high-level investigations and the fines of companies for corruption. So there are some examples like that of successful and quite extensive utilization of rewards to whistleblowers. It is also a very delicate issue, because obviously you establish an incentive of reporting corruption, and you have to put in place. That's a good thing, but you also have to put in place a system of control to make sure that there are no abuses, and the reported instances are effectively true and verified, and also that the system is not abused for frauds, which may be really thinkable. So I'm not sure I would suggest this as a way forward for all sorts of corruption cases. But maybe other colleagues have different opinions.
Thanks very much, Francesco. I think Lee Ambler from ACLI has an answer for us. Thank you, Leah.
Thanks, Peter, and thanks for your presentation, Francesco, as well. It's great to hear what the UNODC has planned in the region. Just in terms of the questions in relation to senior members of law enforcement agencies, I think that the point made earlier about the importance of external independent oversight bodies is key. Because obviously there's political considerations that could be involved. I know that actually in our investigations, we have managed, in one particular investigation, the former Commissioner of Australian Border Force was found to have engaged in corrupt conduct, and that's publicly available on ACLE's website. But I think that independent external oversight is a key factor in being able to hold senior members of law enforcement agencies accountable. In relation to the question on incentives for whistleblowers, in Australia, we don't have a system for financial rewards for whistleblowers, and there's different studies on the effectiveness of financial rewards in terms of whistleblowers coming forward. But there's been some interesting publications recently coming out of the United States which reinforce findings that whistleblowers almost always prefer to report internally first. So I think this comes back to Francesco's earlier point about the importance of effective, trusted internal reporting frameworks. And I note that the International Standards Organization has just recently published its new standard on whistleblower management systems, which provides some practical guidance on what an effective reporting framework looks like. And I think having clear avenues to report, which ACLE does on our website, we have clearly a reporting form to report corruption, but that can also incentivize people to come forward when they know where to report and they can see outcomes from the reports that they make.
Thanks very much, Leah. Any other comments from our speakers before we hand back? Oh, Louise, Dr. Porter, thank you.
Hello, sorry, I don't know how to raise my hand electronically, so I did it actually. Yeah, just to continue on from Leah's comment there about how do you combat corruption when it goes all the way to the top and it's systemic, and obviously it's a very difficult issue, but it is one that other jurisdictions have been able to tackle. But obviously it's a long-term process of reform. Even recently, there have been cases in the UK of chief officer misconduct, where chief officers have been investigated and removed. And so having external oversight, and particularly where those external agencies have got the power to investigate and to sort of bring charges against people as well. But then once those people are replaced, obviously you need to think about who you're replacing them with, and reform happens from the top down as well as the bottom up. So having this sort of process of reform from the top with new leadership that can extend down, but also thinking about then the sort of new recruits coming up and being able to make sure you've got that new culture of people as they come up through the service as well. So that's my comments. Thank you.
Thanks very much, Louise. Okay, well, I think that concludes our short Q&A session. I'll hand back to our MC, Kunpa. Thank you.
Okay, thank you very much, Peter. Now our webinar has come to an end. Thank you very much to you all for your participation and for staying with us until the end of the webinar. Actually, there are some questions in the Q&A box, but unfortunately, we don't have time to answer them all. But the presentation will be shared with all of you, and the speaker provided their email address in the slides. So you may reach out to them directly in case you have any questions that have not been answered yet. So thank you, all speakers, for your insightful presentations, and we hope to see you again in our next webinar. Have a good afternoon, good evening, or good night to you all. Thank you. Bye-bye. สวัสดีค่ะ